Hey everyone, David Holt here. I'm going to go over the U.S. Department of Labor law rule that just came out here that's set to go into effect in March of 2024. It's been on everyone's mind, and I just wanted to give a quick overview. I'm going to reference more in-depth written material that I have that's going to be made available in the link and or on the website. It is Valentine's Day, actually, so happy Valentine's Day, February 14th, 2024. These rules could change. There are lawsuits that are challenging the rule even going to effect at all, so stay tuned for that. But high level, what I want to go over is who this would affect. So anyone who's using independent contractors and is under the U.S. Department of Labor's jurisdiction. So who is that, right? And everyone's like, well, does federal law apply? Does state law apply? I don't know. As a good rule of thumb, if you're a larger business, it's going to apply if you're above $500,000 in revenue. Also, if you are actively moving through interstate commerce. So if you're practicing for a lot of my healthcare clients, if you're, telehealth or you have multiple state practice, I think it's a safe assumption that this would apply to you. And then finally, relating it more to the clients that I serve, if you're accepting any public funding, Medicare, TRICARE, Medicaid, this rule is going to apply. Quick overview. There's 6 factors now. All right. Here they are. Opportunity for profit or loss depending on managerial skill, investments by the worker and the potential employer, the degree of permanence of the work relationship, the nature and degree of control, the extent to which the work performed is an integral part of the potential employer's business, and skill and initiative. So these factors are expanded in other resources that I have, but those are the high level 6 factors. No one factor is necessarily determinative, whereas previously there may have been factors that were weighted higher than others. There is no, superior factor. Also, we now look at the totality of the circumstances and whether or not the worker is economically dependent on the employer or business, which can then, in this multi-factor test, can sway the decision. So scrolling down here, I just want to get into tips and traps right away. Good rule of thumb. So I would say as a general rule, of course, seek legal advice for your individual situation. This is educational. This is not legal advice. I'm not your attorney. But as a safe position, until there's more guidance, for which I suspect there will be through litigation of the rule, enforcement of the rule, public decisions, as well as guidance from the government. But I think as a safe rule of thumb, where we're at here in February 2024, you want to pass at least 4 out of the 6 factors as a slam dunk. Not I don't know, we're kind of half in, half out. You want to be a slam dunk on 4 out of the 6 factors. And in addition to that, you need to have a reasonable argument that the worker is not economically dependent on the business. What does economically dependent on the business mean? Well, here's a simple example. If you've had an independent contractor that's worked only for your business for 30 hours a week plus for the last 3 years, and this is really their only source of income, that would be a clear economic dependence on your business, right? They're really only working for you. This tends to lend itself to more of an employment relationship. Whether you agree with that or not, that's the way the rule has been written and will likely be interpreted. Clients sometimes get upset with the rule, for which I, divert them to yell at their legislators or the government or, their therapists and not me. But you can't opt out of this rule. So what I mean by that is sometimes businesses come to me and they say, listen, my workers don't want to be employees. This is completely voluntary. Plus, I call them independent contractors in my written agreement and I pay them the way I'm supposed to pay them. That doesn't matter. The government does not care if the worker does not want to be an employee, whether you have a written agreement that says independent contractor all over it, and that's their title, and you pay them the way that an independent contractor really should be paid. A couple other things as I'm moving through here in more of a summary fashion. At a bare minimum, we need to update our actual legal written documents to really hit every reasonable defense that we can in all of the 6 factors, and there's language that you can put into the agreement and really tee it up so that if you were under audit, you're actually borrowing language from the actual rules and the factors and using it against the auditor. In addition, As a conservative rule, I mean, I run a very conservative, sleep well at night legal practice. I would say that all supervisees are automatically going to be employees. I just don't see a very defensible argument, not one that I'd represent you for. As well as what I call these career full-time 30-hour contractors. There's just no defense anymore. I don't think the best written and set up in the world is not a case that I would take. I'm sure there are attorneys out there that run a more risky legal practice and are going to wade into the very dark gray waters of the multi-factor test. I am not one of those. And finally, we need to change your actual behavioral control. So let's get to like some really good tips just right off the bat. So first off, all your contractors should be filing a legal entity and actually utilize the legal entity as an independent business. And I'll talk a little bit more about that. We're going to change our relationships with our workers from a business to business. So we're already a business. They're sometimes an individual signing at the very bottom. We want that to be an entity, LLC, corporation, something. In addition, we're not just going to have them go out and file an entity and have this really be a formality. We actually want them to operate a business. I'll tell you what that looks like. Setting up a business bank account, setting up a website, actually taking other work. I'll talk about that in a second. We want to allow our workers to actually negotiate their rates of pay. Now, maybe you do have set rates, but we want to show some sort of negotiation, the type that you would expect from a business to business relationship. This should have already been a no-brainer before this rule came out, but confirm that all of your workers can reject work and choose their own schedule. So they can accept or reject patient appointments. They can choose their own schedule. Maybe they only work Wednesday, Thursday, Friday, things like that. Obviously, if this became so much of a burden that you couldn't even business to business work with them, that you'd probably terminate the arrangement. But that is very different than you choosing exactly when they have to work and which appointments they can take. It's more of like a chronic overview of their work. Here's some examples of what I would expect an independent business to do. So they're doing their own marketing. They're doing their own advertising. Things that you do as a business, they're also doing as a business, even if it's, semi-competitive to you. And I say get at least 5 clear examples. 5 is an arbitrary number, but it feels like enough where, all right, we got 1, 2, 3, 4, 5, not just an LLC. Okay, great. Website. So their own website, which brands them and their business and not like just a link over to yours. Business cards that only have their entity and personal information on it. Paid promotions, ads, or some of the professions have like their little profiles that you can get, like Psychology Today and some of those other ones. A booth at a conference, business apparel, business branded materials, updating the LinkedIn and social media to reflect their individual business, right? Rather than just everything funneling to your business, the main business that's hiring the independent contractor. I'm also a fan of now removing contractors from the company website or extremely clear disclaimer. And I mean like in their face. If I'm a random user that lands on a website, it's very clear that this person is independent. In fact, you would probably be linking to their website if we were really trying to have this work in our favor. And then all the other materials, they should, laptop, their own Wi-Fi, Post-it notes, microphone, headphones, everything that they would need for telehealth or whatever it is they're doing. If you're a medical spa and we're doing injectables, I would like to see the actual injector going and buying their own materials, all of their gloves, the needles, all of that. We definitely want a business bank account. And we want the payments to be to the entity, the business now, not the individual. Confirm that they're actually purchasing their own materials. One exception that I think I have for a lot of my healthcare clients is the EHR. It's just so difficult and intimate to actually having the business relationship work. I think it's nearly impossible to do without, but any other software, having their own emails would be very useful. Having their own, really anything else besides EHR, I'd like to see. Some clients are doing like a rental, rent-a-run model. We want that to be optional, or really only as a formality to enable billing to a payer. Contractors need to be doing all of their own training. They need to know what HIPAA is, do their own training, and have their own written internal policies and procedures manual, since they're their own business. This would be a good thing to document that would also work very well with number 4 up above. If you as the company are doing trainings, you need to stop that immediately. As of March 11th, assuming this is going through, you need to stop that. This is kind of a piggyback on the one above, but we want to document instances of where they're doing advertising, marketing efforts on their own. that probably result in them funneling more business to your business, or maybe even business to themselves because they're moonlighting and now they're doing their own advertising and marketing. That'd be a really good factor, even though it's semi-competitive to your business. That would be a really good factor. And I just threw in, if they were actually going to just divert patients over to you, that should really be considered in the whole scope of, compensating the contractor more for that, or having some sort of negotiation. That would be a really good factor. I'm now a fan with the permanence of the relationship factor to switch to 1 year maximum without automatic renewals in a perfect world. There's clever language that you can use to kind of, I think, win on this factor, but also protect you if you forget to do it, and actually have like meaningful negotiations at the end of that 1 year term. Now, this is going to be, annoying, but it's going to help win on that factor. No more non-competes. Pretty easy. I would say we're going to remove non-solicitations as well, and or make it very clear that clients that they bring in independently are theirs, how we're going to measure that, what to do on a breakup. I think that's going to be a big area for winning on that factor. And finally, you're not going to like me hearing this, but I would actually force your contractors to seek additional work elsewhere, and consider even limiting contractors to a max of 20 hours a week. So what this does is it's going to prevent the economic reality reliance upon your business. It's going to force them to operate as an independent entity and actually seek work elsewhere, that they are then perhaps working at another mental health group, or they're taking business on their own. Kind of a repeat of what I set up above. Interns and, career contractors really just need to be switched to employees. I just want to make this clear. This is kind of confusing. I'm not really happy with how this rule came about, but what's wild is that the IRS can have a different way to classify workers than the US Department of Labor, as well as a few other federal and state agencies. So this is confusing. So if your CPA or accountant says, yeah, per the IRS, here are the factors that we still follow, those could be different than the US Department of Labor law 6-factor test. Extremely confusing, rather annoying, but that's the way we have it. So I just want to make that clear. I would hope that in the future here, we kind of have a conformity of factors, but as of today, we don't. Just like a quick rundown, independent contractors versus employees. I'm not going to go over this, but I really want you to take a peek at this table if you can. It really breaks down it. In order to give a contractor versus an employee $100,000, like I am the business spending that, I just kind of broke down how much the worker would be paying versus how much the business would be paying. And then I just, based on my interactions with clients, and I'm probably on the conservative or high side for, additional costs for a business for having an employee. These are complete estimates, talk to an accountant or CPA. I will note that usually contractors are paid more, I say that in quotes, to account for the fact that they have no benefits, employment protections, they're paying their own taxes. I really do think that should be taken as a factor if you are switching. I do have some really good, if you want to look at some of the FAQs. Again, this is not meant to be direct legal advice. You would need to engage with an attorney for that. Simply reading or watching a video is not going to be enough, and you assume the risk if you don't engage with a professional. Look at the link at the bottom to read more thoroughly on this. I'll be releasing a lot more resources, and follow me to stay on top of that. Thanks.